Hello, everyone. Welcome to the Title IX training. My name is Eric Feldman. I'm an attorney with Miller Johnson. Today, we'll be presenting the Title IX training. It'll be broken up into several parts with different speakers. I will commence with the background of the Title IX, the history, comparison of the programs, the scope of the harassment and sex discrimination, and pregnancy discrimination as well. Title IX of the Education Amendments of 1972 provides what? No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. Let's look at the background of the regulations. We had 2020, we had Title IX regulations in regards to the new regulations upcoming. In March 2021, there's an executive order issued on guaranteeing an educational environment free from discrimination on the basis of sex, including sexual orientation or gender identity. In April 2021, the Office of Civil Rights launched a comprehensive review of the Title IX regulations. In June 2022, OCR issued proposed changes to the Title IX regulations. And finally, in April 2024, the final regulations were issued with an effective date of August 1st. So let's look at a comparison of the Title IX coverages when we had the last regulation changes in 2020 versus the new ones coming up on August 1st, 2024. Let's look at the in the education program or activity language that includes conduct at what? Buildings or other locations that are part of the school's operation, including remote learning platforms, off-campus settings if the school exercises substantial control over the respondent and the context in which the alleged sexual harassment occurred, and off-campus buildings owned or controlled by a student organization officially recognized by a post-secondary school, such as a building owned by a recognized fraternity or sorority. So the 2024 regulations literally just say conduct that is subject to the school's disciplinary authority. The 2024 regulations focuses on the reach of these schools' disciplinary authority. So to the extent the school would discipline a student for off-campus behavior that affects the school environment, for example, off-campus use of racial slurs toward another student, it would do the same for conduct involving sex discrimination. What about the scope or definition of sexual harassment, looking at the 2020 regulations now? How do we apply sexual harassment? What did it include? It included conditioning, an aid, benefit, or service on an individual's participation in unwelcome sexual conduct, quid pro quo. Also, unwelcome conduct on the basis of sex determined by a responsible person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to a program or activity offered by a school. Or sexual harassment includes sexual assault, dating violence, domestic violence, or stalking, as defined by federal statutes known as the Clergy Act or the Violence Against Women Act. So what did the 2024 regulations do? It broadened the application of the grievance procedures and other responsibilities to apply to sex discrimination, including sex-based harassment. Sex discrimination means discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. Sex-based harassment is a form of sex discrimination. Sex discrimination also created for the 2024 regulations special rules for pregnancy or related conditions. Pregnancy or related conditions, what does it mean? It can mean pregnancy, childbirth, termination of pregnancy, or lactation. Medical conditions related to a pregnancy, childbirth, termination of pregnancy, or lactation, or recovery from pregnancy, childbirth, termination of pregnancy, childbirth, termination of pregnancy, patient or related conditions. All employee notification obligations. This is required. So when a student or a person with a legal right to act on the student's behalf informs any employee of a related condition, the employee must do the following. provide contact information for the Title IX coordinator, and explain that the Title IX coordinator can coordinate actions to prevent sex discrimination and ensure equal access to the school's education programs and activities. What about sex discrimination rules continued, actually? So what are the Title IX coordinator obligations under the pregnancy or related conditions? They must provide notice of Title IX rights related to pregnancy or related conditions and a notice of non-discrimination. They must make reasonable modifications based on students' individualized needs to policies, practices, or procedures as necessary to ensure equal access. So what does reasonable modifications mean? It may include breaks during class to express breast milk, breastfeed, and attend to related health needs, including eating, drinking, and using restroom, intermittent absences for medical appointments, access to online homebound education, changes in schedule or course sequence, extensions of time for coursework and rescheduling tests and examinations, allowing students to sit, stand, or carry, keep water nearby, counseling, changes in physical space or supplies, elevator access, or other changes to policies, practices, or procedures. You must consult with the students. The student can accept or decline. The obligations continued. For the Title IX coordinator, they have to allow the student to voluntarily access any separate and comparable portion of the school's program activity, allow the student to take a voluntary leave of absence to cover, at a minimum, the period of time deemed medically necessary by the student's health care provider. If a more generous leave policy would allow a longer period, then the student would be allowed to take that leave under that generous policy. Upon return, the student must be reinstated to the academic status as practicable, the extracurricular status the student held when leave began. And provide a lactation space for student, which is not a bathroom, is clean, shielded from view, and free from intrusion by others, for use for breastfeeding or expressing milk. And finally, you must not require supporting documentation unless necessary and reasonable. Determine whether reasonable modification or other accommodations needed. You treat, quote, pregnancy or related conditions, unquote, the same as other temporary medical conditions. Not require the student provide certification of healthcare provider, but the student is physically able to participate in a class program extracurricular activity unless the certified level of physical ability health is necessary to participate. All students participating are required to prefer certification, and information is not used as a basis to discrimination based on pregnancy or related condition. So this concludes my presentation in regards to the history and looking at the scope and pregnancy discrimination. I will now turn it over to Attorney Adam Blaylock. Thank you.
My name is Adam Blaylock. I've been licensed as an attorney since 2013 and spent about 4.5 years as the Director of Human Resources and Title IX Coordinator at Lincoln Consolidated Schools in Ypsilanti. So I have the benefit and the joy of both dealing with these things from the legal perspective as well as from the practical perspective. The 2024 revised Title IX regulations expand the definition of sex-based harassment. So we're going to briefly touch on those definitions as well as some of the differences between the 2020 regs as well as the 2024 regulations. And then we'll also go through a couple of hypotheticals and discuss retaliation as well. So when we talk about sex-based harassment under the 2024 Title IX regulations, we're talking about harassment on the basis of sex, including harassment on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. That falls within one of the following categories: quid pro quo harassment, hostile environment harassment, or specific offenses. What's notable is that those definitions are more expansive than what we saw under the 2020 regulations. You'll note that many of the legal challenges that are ongoing are focused on the expansion of Title IX beyond biological sex to incorporate some of these other concepts. Next, we'll turn to the comparison of sexual harassment between the 2024 regulations as well as the 2020 regulations. So what jumps out as we take a look at the differences here is the definition shifting from being just employees under the 2020 regulations to also applying to agents or other persons with authority that either explicitly or impliedly condition the provision on someone's unwelcome participation in sexual conduct. So rather than applying directly to our employees, it also applies to other potential agents as well. It's important to recognize this as we go through our Title IX analysis, because that will be incredibly important for determining whether or not it's appropriate to move forward with an investigation after a formal complaint, and also the impact of the regulations on other facets of the Title IX analysis. Next, we'll take a look at the shifting definition of sexual harassment. So under the old regulations, you'll note that there was a requirement that it was severe, pervasive, and objectively offensive. However, on the new regulations, the 2024 regulations, it is severe or pervasive based on the totality of the circumstances. So this definition, again, is going to expand the application of hostile environment analysis to capture more behaviors, and it's going to capture more of the types of things that would have, under the old regulations, been dismissed or been deemed not to be sexual harassment, hostile environment harassment. As we continue analyzing the definition of sex-based harassment, we have to recognize that this is a fact-specific inquiry. That means that we need to go through this process and apply the facts of each particular complaint and each particular investigation and look at these factors. The first factor is the degree to which the conduct affected the complainant's ability to access the school's educational program or activity. Next, the type, frequency, and duration of the conduct. Next, the parties' ages, roles within the school's education program or activity, previous interactions, and other factors about each party that may be relevant to evaluating the effects of the conduct. Fourth, the location of the conduct and the context in which the conduct occurred. And finally, other sex-based harassment in the school's education program or activity. I want to reiterate one more time. What's important here is that hostile environment sexual harassment is a fact-specific inquiry, and we have an obligation to consider each of those factors as we go through that analysis. I also want to take a moment to compare the definition of the specific offenses and the differences there, because while the same standards are being applied under the 2024 regulations, there are more specific definitions within the regulations rather than cross-referencing the Clery Act and the Violence Against Women Act. And this is important because under the old law, under the old regulations, we would apply the same standard in those circumstances. And so I think the point that I'd make here as it relates to our analysis whenever we're dealing with a specific offense type of Title IX investigation or Title IX complaint is that we go back and we review those definitions specifically so that we make sure that we understand and we're applying the appropriate standards. For example, for sexual assault, an offense that's classified as a forcible or non-forcible sex offense under the Uniform Crime Reporting System. And these kinds of offenses include forcible rape, forcible sodomy, sexual assault with an object, forcible fondling, incest, and statutory rape. Specific offenses also include stalking. Stalking is engaging in a course of conduct directed to a specific person that would cause a reasonable person to fear for their safety or the safety of others, or suffer substantial emotional distress. And those are the very specific standards that we should apply as we review our Title IX complaints and conduct our Title IX investigations. Next, dating violence. So violence that's committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim, and where the existence of that relationship is determined based on the consideration of the following factors: the length of the relationship, the type of relationship, and the frequency of interaction between the persons involved in the relationship. We also turn to domestic violence and define that. So a felony or misdemeanor crime committed by a person who is a current or former spouse or intimate partner of the victim under the family or domestic laws of the jurisdiction, or a person similarly situated to the victim. They're cohabitating or have cohabitated with the victim as a spouse or intimate partner, share a child in common with the victim, or commits acts against a youth or adult victim who is protected from those acts under the family or domestic violence laws of the jurisdiction. Briefly, we want to go through a couple of hypotheticals and raise those as thought experiments, recognizing that as we go through these sex-based harassment hypotheticals, that we should be applying the standards that we just discussed. So the first hypothetical is, we have a teacher who asks a female student who's in a bad mood if it's that time of the month. And then the second layer to that fact pattern is if they inappropriately touch a female student's upper inner thigh. For our next hypothetical, we have a female student who daily teases a male student about his sexual orientation in the cafeteria, causing the student to avoid lunch, who frequently squeezes a male student's bottom and calls him sexy. It bothers him and he's told him to stop, but it hasn't really impacted his daily life or education. And finally, we have a hypothetical where a male student snaps a female student during class, telling her she looks hot today and asking her on a date. The female student is deeply uncomfortable because she has a history of trauma and starts skipping class. So I want to reiterate that we should be going back to those sex-based harassment standards in order to identify whether or not sexual harassment has occurred in these cases. And so as we flip back to those standards, we can see the degree to which the conduct affected the complainant's ability to access the school's education program or activity. So those hypotheticals at varied levels of impact to the educational program. The type, frequency, and duration of the conduct is also critical. So the more frequent that conduct is occurring, for example, if you've got daily touching, that is more likely to be deemed sex-based harassment. Next, the party's ages and roles within the school's education program or activity. So in instances where you have sexualized behavior between a teacher and a student, that again is more likely to be deemed sex-based harassment. Next, the location of the conduct and the context in which the conduct occurred. So again, depending on the circumstances, that can err towards or against the definition of sex-based harassment. And finally, other sex-based harassment in the school's education program or activity. So that's important because if you've got other similar conduct occurring, it's important to incorporate that into the analysis in order to determine whether sex-based harassment is occurring. Finally, we want to touch on the definition of retaliation in the 2024 regulations. So retaliation under the 2024 regulations means intimidation, threats, coercion, or discrimination against any person by the school, a student, an employee, or another person authorized by the school to provide aid, benefit, or service under the school's program or activity for the purpose of interfering with any right or privilege secured by Title IX, or because the person has reported information, made a complaint, testified, assisted, or participated, or refused to participate in any manner in investigation, proceeding, or hearing under or other Title IX process. So ultimately, as most of our HR-related folks are going to know from their prior experience, it is incredibly important to make sure that there is not retaliation, whether it's by the organization itself or others within the organization, when someone comes forward, participates, files a complaint, participates in an interview, or chooses not to do any of those things, because the decision to move forward with those things is individualized based on each person.
Thanks, Adam. Consistent with the 2020 regulations, every school is required to designate a Title IX coordinator. That person is responsible for overseeing and coordinating the school's compliance efforts with Title IX. Anyone who's served in that role knows that it's a huge job. So many schools have designated 2 or more employees to serve in that role. The 2024 regulations clarify that while it's fine to have multiple Title IX coordinators, one of them has to retain ultimate oversight. The 2024 regulations also clarify that the Title IX coordinators may delegate specific duties to designees. So for instance, the Title IX coordinator could designate responsibility for making reasonable modifications for pregnant students, but they still would need to retain ultimate oversight over that responsibility. The 2024 regulations require that each school publish a notice of non-discrimination, where the school must provide information about how to contact the school's Title IX coordinator. That notice must include the name or title, office address, email address, and telephone number of the Title IX coordinator or Title IX coordinators. It's critical that all employees know who their Title IX coordinator is and how to contact them. This is because all employees have a responsibility to either notify the Title IX coordinator or notify others how to contact the Title IX coordinator whenever they have information about conduct that may reasonably constitute sex discrimination. So, unless you are a confidential employee, which I'll explain in a minute, all other employees have an obligation to report to the Title IX coordinator anytime you have information that, quote, may constitute sex discrimination. I know that Adam explained the definition of sex discrimination, including sex-based harassment, but keep in mind that the duty to notify the Title IX coordinator applies to conduct that may constitute sex discrimination. So you don't need to know for sure that conduct would constitute sex discrimination. When in doubt, report it to the Title IX coordinator, because the Title IX coordinator is the person who can help you determine what needs to be done with that information. The only employees who do not have a duty to report conduct that may constitute sex discrimination to the Title IX coordinator are, quote, confidential employees. So the confidential employee role is a new one under the 2024 regulations. The reason that the Department of Education created that role is that there was a concern that students, employees, and other people who may be reporting sex discrimination might not feel comfortable talking to anyone about what happened out of fear that once they make a report of sex discrimination, they won't have any control over whether it moves forward into a Title IX process. So the Department of Education created this role to give those folks an avenue to make the report and gain information without necessarily it getting out of their hands and turning into a Title IX complaint. So who are these confidential employees? They are, one, employees whose communications are privileged or confidential under state or federal law. So, for instance, if you have a licensed social worker or a nurse, they may have legal duties to keep information privileged or confidential under law. But importantly, an employee is only considered confidential when they're acting within the scope of those duties. So, for instance, if a student reported conduct that constitutes sexual harassment to a licensed nurse while they're receiving healthcare services, the nurse would be considered a confidential employee. However, if the nurse is also a volleyball coach and one of her team members tells her after practice, the nurse would not be acting as a confidential employee. Another type of confidential employee are employees who the school designates as confidential for the purpose of providing confidential services regarding sex discrimination. So again, these employees are only confidential if information is reported to them within their designated role. So for instance, let's say the school designated its high school counselors as confidential employees. If a student went to the counselor at school and shared information about conduct that may constitute sex harassment, the counselor would be considered a confidential employee. However, if the counselor is also supervising a club like the Gay Straight Alliance and receives information through that role, then they would not be a confidential employee. Finally, for post-secondary institutions, confidential employees include employees who are conducting an institutional review board approved human subject study designed to gather information about sex discrimination, but only with respect to information that's received while conducting that study. So, as I've mentioned, the confidential employees I've described do not have a duty under Title IX to report to the Title IX coordinator. However, the fact that they don't have a duty to report to the Title IX coordinator does not negate any other legal duty that they have to report information that they receive. For instance, if a student reported that a teacher had sexually assaulted them, then the confidential employee would still have a legal duty to report to Child Protective Services. Also, although confidential employees aren't usually required to notify the Title IX coordinator when they receive information about conduct that might constitute sex discrimination, they do have an obligation to share information about Title IX with the person reporting the conduct. Specifically, upon receipt of a report, the confidential employee has an obligation to explain their status as a confidential employee when they are not required to notify the Title IX coordinator of conduct they may constitute sex discrimination, how to contact the Title IX coordinator, how to make a complaint of sex discrimination, as well as what the Title IX coordinator may be able to do for the complainant, including offering and coordinating supportive measures, initiating an informal resolution process, or initiating an investigation under the grievance procedures. In my opinion, this seems like a lot to expect a confidential employee to remember to say, particularly during what might be an emotional conversation. So while it's not required to provide this information in writing, Miller Johnson put together a document containing all of this information that a confidential employee could use as a guide for the conversation or to give the reporting person at the end.
This is not legal advice nor intended to create or constitute a lawyer-client relationship. For any information material, readers who have specific questions or problems should consult their lawyer. So I would like to thank and conclude for this Title IX presentation for all employees. If you have any questions at all, you can reach out to anyone at the Educational Practice Unit of the Miller Johnson Law Firm and be more than happy to assist. Thank you and have a wonderful day.